From the private side is Sheldon Esbin. Sheldon spoke very capably at a Law Society program on competition law I had the privilege to chair a few months ago, and at that time provided me with a resume for introduction purposes, which I will read. Sheldon Esbin, Osgoode Hall Law School, 1964, called to the bar, 1966, partner Spencer Romberg. Now, just to show that Sheldon has gained experience over the past 8 months or so, I will read Sheldon's most recent resume. Graduated from Osgoode Hall in 1964. Had one brief moment of glory when he was awarded the Law Society third prize in bar admission in 1966. Acts for about 24 advertising agency, reviews their advertising for so-called legal content. Does not consider his writing the legal mice type that appears at the bottom of advertising contributes to anyone's short-sightedness except his own, because no one else but him reads it. Sheldon has written and spoken on various aspects of marketing and advertising law for about 25 years, but it feels like 50. Now, Sheldon's sense of humor has always been delightful, and it's nice to find it reduced to mice type. Sheldon Esbin.
Thank you, Wayne. The subject of my paper is regulatory approvals, what they are and how to get them. Wayne knows that I'm very skeptical of the process, and I'm probably very outspoken, and maybe that's why he's asked me to speak to you today. What regulatory approvals are is very easy to explain. How to get them is probably more art than science. Most advertising doesn't require any sort of pre-clearance, especially at the provincial level, liquor, wine, and beer advertising being notable exceptions. At the federal level, however, the situation is different. The federal government has established regulatory control of the airwaves under the Broadcasting Act. The federal government is empowered to review and censor advertising in defined categories. The categories include advertising of all foods, drugs, cosmetics, medical devices, and advertising aimed at children. Either or both of two federal ministries, Consumer and Corporate Affairs and Health and Welfare Canada, review all proposed broadcast advertising in these categories, and they either approve of them, in which case the commercials are assigned a number that's valid for broadcasting them for a given period of time, possibly 6 months or a year, or the advertising is rejected. The fact that advertising is often rejected, or that the approval process is so long and can be so tedious, does put advertisers in these ministries in apparent adversarial positions. However, I want to say it early in my presentation, and that to the credit of many of the government officials in these two ministries, and some of them are with us today, they've attempted to conduct a continuing dialogue with the industries most affected. This dialogue has always been open, it's always been frank, it's always been honest. Occasionally it's even been productive. I've even heard rumors about the regulation, as was mentioned this morning, starting as far back as the beginning of Pierre Trudeau's quest for a more just society, which you can now read about in the best-selling work of fiction of the same name. There was talk of deregulation. But in my opinion, it hasn't happened. What does happen, and what has happened, is if you intend to broadcast your advertising, and the product being broadcast is, as I said, a food, drug, cosmetic, or medical device, or the advertising is aimed at children, the proposed advertising in a script or storyboard form is submitted to Consumer and Corporate Affairs in Ottawa, or more accurately to a cavernous building, 50 Victoria Street on the Hull side of the river. And what happens next, or what appears to happen next, is the proposed advertising sits in a basket on someone's desk for 2 or 3 weeks, I suppose, for the advertising get properly aged. And then, just as the papers are browning and curling at the edges, somebody looks at it, and they determine whether or not it complies with the laws, the legislation, or the regulations which impact on it. As an example, suppose that the advertising claims that Ben Johnson runs fastest when he eats Kentucky Fried Chicken. Okay. After testing the chicken for illegal substances, the government officials will look at the Food and Drugs Act possibly the Canada Agricultural Product Standards Act, maybe the Consumer Packaging and Labeling Act, all to determine whether the advertising offends any of these acts. I should point out that approval of the commercial at this stage isn't a guarantee of immunity from subsequent prosecution under the Competition Act for false or misleading advertising, although this would be highly unusual. As well as reviewing the impact of the relevant legislation and regulations on the commercial, government officials will review the food commercial for compliance with the Guide for Food Manufacturers and Advertisers. This guide is published by the Ministry of National Health and Welfare. While the guide has no legal authority, and it's intended only as an interpretive aid, it is in fact enforced by government officials as the holy grail of food advertising law. The Guide to Consumer Drug Advertising serves the same purpose for interpreting drug advertising laws and regulations. Both of the guides are sort of compendiums of government policy, which one would hope and expect that would be helpful to advertisers and government alike in understanding and interpreting the many laws and legislation that impact on the advertising of these products. The guides are, of course, intended to be applied to advertising in all media, in both print and broadcasting. What happens, however, is that there is virtually no enforcement of the guidelines in print advertising. While in broadcast, the guidelines are enforced not as interpretive aids, but rather as if they were statements of law. In the broadcast advertising of food and drugs, government officials cite the published guidelines as if they had the force of law, and on that basis alone, they can refuse to grant a clearance number to a commercial, so that no further enforcement of any kind is ever needed. There's no need to investigate or prosecute an alleged offense of broadcast advertising, as would be the case with a print ad. Why bother? You have a lot of power concentrated in the hands of a few government officials by the Broadcasting Act, which allows them to prevent the airing of a commercial without doing anything more than citing a paragraph in a government-published bulletin. There's no investigation. There's no need to convince the Department of Justice, as would be the case with false and misleading advertising under the Competition Act, that an offense has occurred, because no charges are ever laid. There's no trial, there's no judicial consideration, there's no verdict, there's not a determination of guilt or innocence. And what's most important is there's no precedent. There's no legal precedent, there's no jurisprudence, or stare decisis, as we lawyers call it, to establish a guide for someone to make a future decision. And here, I think, is the heart of the problem. The guidelines have been created by government officials, by the bureaucracy, although sometimes aided and abetted, I admit, by industry, to interpret the laws and the regulations. But with no jurisprudence, how does one interpret the guidelines? The guidelines were, I believe, intended to provide the spirit of interpretation to the laws and the regulations. But being interpreted solely by government, with the perspective only of government, by officials who have absolute authority, the guidelines are applied as if they were the letter of the law, not the spirit. And this procedure can become unfair, especially because sometimes the guidelines are silent, or they're ambiguous, or sometimes they're even wrong. Let me give you an example of silent. The Guide for Food Manufacturers and Advertisers doesn't state whether a commercial that literally complies with the guide can be refused or should be refused pre-clearance when the product itself is suspect, but the product is not shown in the commercial. For example, suppose that a government official believes, correctly I assume, that the label of the actual product is either too big or too small and doesn't comply with the Packaging and Labeling Act. Should that official have the right to refuse to pre-clear a radio commercial for the product where the label is totally irrelevant? You can't see radio. The guide doesn't provide an answer to this question. Let me give you an example of ambiguous. Anything on a label is advertising. Should the name of a product be a reason for rejection of advertising? Suppose that the product's registered name or trademark is Slim Fast or Slim Quick, a diet product, a meal replacement. The name of the product is part of the advertising, But is it a representation, for example, that you will lose weight faster, become slim quickly? Should a commercial advertising this product be refused pre-clearance solely on the basis of an implied representation by the registered name of the product? It's an ephemeral concept. I'm not sure. The guide isn't clear. I suppose I should now give you an example of where the guidelines are wrong. I could, but I won't. I won't because it's impossible. It's impossible to convince an official in Ottawa that the guideline is wrong. Even if it is, it's a fruitless argument. You can only argue that the official's interpretation of the guideline is wrong. And no doubt, sometimes their interpretations are wrong because they're nothing more than judgment calls. And judgments can be wrong. It's not a sin to be wrong. Officials being asked to interpret guidelines are entitled to be wrong as anyone else. I don't for a moment doubt their sincerity or their integrity or their commitment to duty. But when there's so little likelihood that a court will ever review their decision, it becomes a heck of a lot easier to make wrong decisions. Of course, it isn't only poorly drafted regulations or improper interpretations that lead to unfairness. Sometimes things like technological advances in product development is the culprit. The government's ability to respond to new technology with updated regulations and still later with updated guidelines covering the updated regulations can create problems. I'll give you an example. Some years ago, Perrier, or as it may soon have to be called Classic Perrier without benzene, was able to advance the technology of bottling gasified waters. And Perrier was able to sink pipes into the Earth's strata to collect the natural forming carbon dioxide gas, and so reduce the gas levels in its source waters underground. And then later they were able to reconstitute the gas into the water as part of the bottling process to the original levels that would appear in a state of nature. The final product didn't differ at all from what the product would have been like in a state of nature, and so Perrier was labeled as naturally carbonated water. The government pointed to a regulation of the Food and Drugs Act which said that the word carbonated, which could, to a consumer could mean artificially carbonated as well as naturally carbonated. They said that the word carbonated must be used as a first designation of the common name of the product because carbon dioxide was being reintroduced to a level higher than existed in the water when the water reached the Earth's surface. And the legislation talked about the point of emergence, when the water comes up to the level, and they refused to look at the argument that the carbon dioxide level is only lower at this point of emergence because it had been extracted earlier below ground by this new technology. When the legislation was originally introduced, God knows how many years ago, the technology to lower the gas in the underground water prior to its emergence didn't exist. Perrier battled the Department of Consumer and Corporate Affairs on this issue for 5 years. It wasn't all bad. I did get a trip to France, to Nimes. I visited the Perrier plant. It's huge. It's just absolutely vast. It has about 100 acres under the roof. And only the scientists know what's going on there. And even then, I'm sure, only on a need-to-know basis. And Perrier never did change its label, although the recent revelations about its filtering its gas may impact on its natural claim, and I understand that they are going to be changing their labels. They've been given until August to do so. A few months ago, the Dole people ran into a similar kind of technology problem. Dole manufactures fruit juices. The crushing of grapes, oranges, pineapples, grapefruits, apples, what have you, constitutes juice. That's what a consumer thinks of as juice. But the word juice isn't defined by any legislation. What the Food and Drugs Act does, it defines different juices. For example, pineapple juice is defined as being the juice from pineapples, which contain certain additives and sweeteners and other vitamins. That's pineapple juice. But Dole developed the technology to extract juice from, of all things, bananas. The government position was that There was no such thing as banana juice in the legislation. When you crush bananas, you get banana puree. So there being no legal recipe for bananas, Dole was told that only those products or combination of products which refer to specific juices defined in the legislation could be called juice, such as pineapple or pineapple orange. The flavors containing banana, such as pineapple orange banana, Dole was told, would have to be called puree. The ruling ignored the fact that the consistency and viscosity of all the flavors, including the banana, were virtually identical, and that the various flavors were going to be positioned side by side on the shelves of the various supermarkets. Now, I guess this is an example of how the system can work well, because the commercial was eventually approved as pineapple orange juice with banana, rather than pineapple orange banana juice. The word puree was thankfully dropped. Other problems can arise because sometimes the enforcement by the regulatory bodies is not even, which can be very costly to advertisers in a competitive marketplace. For example, when a more restrictive or a new restrictive policy of interpretation is introduced, it will often be first enforced on the next advertiser who, after the implementation date, requests a pre-clearance for its commercial. This gives the advantage to advertisers who may still have 3 or 6 months left to run on a previously approved commercial. They remain unaffected by the new restriction during the balance of the approved period, and that gives them a market advantage. Another example of uneven enforcement may be when one advertiser has been able to negotiate an agreement with government allowing it to advertise in a certain way, but the contents or even the existence of the agreement is unknown to the competitors. A competitor thinking it will be allowed to advertise in the same way is surprised to learn that it cannot. As an example, I recently acted for Diet Centers, Inc., who are the largest chain in the United States of weight loss clinics. They're the ones that use Susan St. James as a spokesperson in their television commercials. Although the television commercials which they submitted to Health and Welfare Canada for approval made no reference to vitamins, approval was refused because the clinics did sell vitamins in the clinics, and vitamins, as we all know, are drugs. And the Guide to Consumer Drug Advertising says that endorsement of a drug by an actor isn't acceptable. So we had the situation of a commercial which made no reference to vitamins, being unable to use a famous person as a spokesperson or an on-camera announcer because the clinics did sell vitamins in their stores. We later learned that a competitive weight loss clinic that sold both vitamins and foods in their stores had negotiated an agreement with Health and Welfare Canada, allowing them to use celebrity advertising in return for agreeing to discontinue selling any vitamins. Celebrities aren't prohibited from selling or promoting food products. In refusing my client commercial approval, Health and Welfare Canada, or at least the official there, intentionally ignored the fact that the commercial made no reference, either visually or verbally, to vitamins. Diet Centers, when they had submitted the commercial for approval, had absolutely no idea about the existence of this agreement with the competitor. When a meeting with the officials in Ottawa brought no change of mind, we brought an application by an originating notice of motion in the federal court asking for a writ of mandamus requiring the minister to approve the commercial. Among other things, we pleaded Section 2B of the Canadian Charter of Rights and Freedom, which guarantees freedom of expression. Shortly after the motion was brought, the Department of Justice relented. They consented to an order allowing the commercial to be broadcast with Susan St. James as a spokesperson. Unfortunately, consent orders don't create judicial precedent on how to interpret the guidelines. I almost wish that Diet Centers had refused to accept the consent order without their day in court. But every lawyer knows that feeling. And I suppose the right thing happened. But the government official who rejected the commercial took a position that extended the prohibition against using famous people, far beyond what I think was ever intended by the guideline. He refused to look at what I call the big picture, what the prohibition had clearly intended. And the lack of judicial precedent only encourages this confining perspective. What's the big picture? Well, right now, for example, the food preclearance group, which Katharine Gourlie will talk about in a few moments in Ottawa, is very short-staffed. It takes about 2 or 3 weeks before anyone even looks at your commercial after you submit it. It's clearly too long a time to have to wait, especially because sometimes you're told that 1 or 2 words need changing, and you have to resubmit new creative and wait another 2 or 3 weeks for clearance. When the government's mandate is to help both advertisers and consumers in the marketplace, to me the big picture suggests that it'd be prudent to pre-clear where there's no issue of any possible harm to consumers. Have an amnesty period, rather than nitpick the commercial and impact negatively on the marketplace. Then when the advertising backlog is cleared, there's again an opportunity to nitpick the commercials. I once had a broadcast commercial for an antiperspirant rejected because the soundtrack contained mysterious music. Another time, Shoppers Drug Mart, who we've acted for 15 years, had a commercial rejected because they talked about the low cost of Life brand products. They said it was tantamount to comparative advertising. That's a good example of how the guideline can be improperly enforced. The drug guideline says that, generally speaking, comparative advertising of drugs should be avoided because drugs are best promoted on their own attributes. That's true. But where you have common drugs like aspirin, and they're all exactly the same because they all conform to a legal recipe, what's the harm of promoting them on a comparative price basis? It happens in print all the time. Why not on television or radio? The government officials who participate directly in the regulatory approval process are, in my estimation, not encouraged to look at the big picture. That is, what's best for everybody, the advertiser, the competitors, the public, everybody in the marketplace. With no judicial scrutiny, there's a tendency to forget that freedom of expression is the important principle in our society, and if there's no need to restrict the freedom, why do it? The idea is not to determine how restrictive the rules can be interpreted, but rather how liberally they can be interpreted. But enough of my criticizing the process. I'm probably spending too much time doing it anyway, and I'd like to give you a few suggestions how to better operate within it. Remember that in following any suggestions, modify your strategy to take into consideration any procedural requirements established by the regulations themselves. 1, know the regulations as well, if not better, than the officials with whom you will be dealing. It's not their job to instruct you in the rules, and many will not. Therefore, don't telephone the person at Health and Welfare Canada who's redlined your script until you've carefully analyzed why the red lines are there in the first place, why they may be justified, and what arguments you're able to advance to overcome the censoring. If you prefer to call and ask, I recommend that the person who makes the phone call be strictly on a fact-finding mission. Don't let it be the senior executive or lawyer who's going to advance your argument later. Have some clerical person do it. Let them humbly and politely ask for the reasons for the red lines and record them faithfully and say goodbye. 2, many of the regulations, especially regarding food and drugs, are technically complex. Utilize your research and development people, utilize the data that's available to you, because often they can provide you with a technical counter-argument to the reasons for the rejection of the advertising. 3, don't lose sight that while the government official's job is to protect the entire public, and your client or you rely on the same public for support, you may be in an adversarial position. This is sometimes a difficult concept to understand. Suppose that your commercial is rejected, but your client has an available pool of alternative commercials which it can use. This is not the kind of information I would give to the government. You have to always, of course, be honest, circumspect with government, never lie. But still, I wouldn't tell them about the alternatives that were available to me, because that's not relevant to the issue of whether the rejective advertising should be approved. 4, when the issues can't be resolved by correspondence or telephone meetings, the next step is often to meet with government, usually in their offices. This is in fact a form of informal appeal of their decision, as the person who made the initial ruling will invariably ask for one or more of his superiors to attend. When attending such a meeting yourself, place no credence at all in the number of people on your side who are going to come to the meeting. The more the merrier may be true at a party, but this isn't a party. And I can assure you that you won't prevail because you outnumber the government officials there. Leave your sales manager at home. Also, the exalted position of the people attending or the great distances that they travel or elsewhere will impress no one. Bring only those people who are able to provide the best evidence on a first-hand basis, and I recommend that legal counsel be there. 5, the meetings are intended to provide a forum for negotiating a resolution of a problem. Therefore, follow the important rules of negotiating. Plan your strategy in advance. Leave open as many options as possible. For example, a conditional or short-term approval of a commercial may be better than no approval at all. There's no point in assuming an all-or-nothing posture if all that you can realistically hope for is a short-term or conditional approval. 6, use all of the arguments and strategies available to you. It's surprising how often the winning strategy is overlooked. A client was refused approval of a radio commercial by a TV network because the commercial claimed that the Cineplex coupon that it was offering as a sales premium was worth X dollars, X being whatever the then current adult admission fee was at Cineplex. The network lawyer argued that the coupon was worth less than X because you couldn't use it on Saturdays or holidays, and no argument of any kind would persuade him to change his mind. The client changed his mind by convincing the sales manager that the network couldn't afford to lose the revenue from broadcasting this commercial because of such a whimsical legal argument. The commercial did run, but I suspect that the CBC lawyer was correct. It was a judgment call and on both of our parts. 7, don't make threats unless you're prepared to carry them out. Don't threaten to litigate unless you're prepared to do so. As you know, we Canadians are very reluctant to litigate. It's no coincidence that my Diet Center client was an American. Also, multi-product companies express the fear that if they're successful in litigating for one product, the government will hold a grudge and hassle them in providing approval for other products. Don't believe it. The opposite's the case. Once a company does litigate to enforce its rights, it will not later be singled out for unfair treatment. In fact, it will be respected as a company that enforces its rights, and in the future, its arguments will be given serious consideration. So in conclusion, if you wish to persuade government regulators to reverse an unfair or improper decision, you must be prepared. Familiarize yourself with all the relevant rules and regulations, and with the product which is to be advertised. Don't be unreasonable or inflexible, but be prepared to advance all the arguments which might possibly persuade the regulators to approve the commercial in question. Thank you.
Hearing the story about the banana puree reminds me of an article or piece that Hart Pomerantz, a fellow student of mine at University of Toronto Law School, wrote about the Wild Birds Act. Bird being defined as an animal with feathers, and Hart's whimsy led him, of course, to the horse on whose back a pillow had been broken, and the treatment of that horse under the Wild Birds Act. Sometimes one can get strange results from regulation. I'd like now to introduce Katharine Gourlie. Katharine is, to begin with, a pharmacist. Graduated from University of Toronto about the time I did in pharmacy. Katharine has had a distinguished career with the federal government. She has held various positions in the Privy Council office, in that office most recently being Director of Operations, Government Operations, and Labor Relations Secretariat. Katharine, in 1989, took over the position of Director, Consumer Products Branch, Consumer Affairs Bureau, Consumer and Corporate Affairs. As Sheldon indicated, she is ultimately responsible for food broadcast ad clearances, and I'm really looking forward to hearing her comments on regulatory approvals in general and her own branch's approvals in particular. Katharine?
Thank you very much. I imagine all of you are now wondering, how can you hive off some of that income that Sheldon's made off the Department of Consumer and Corporate Affairs? It's quite evident that we've contributed significantly to his well-being over the past few years, including worldwide travels. That being said, I knew that today was going to be like going into the hornet's nest, perhaps, with practitioners, both from the legal profession and from the advertising profession. I will not try and make excuses, apologies for the problems that have been experienced over the past few months. Those of you who are in contact with the advertising clearance section know that we have been short-staffed as a result of retirements from what one might call the institutional memory of the department. We lost 4 of our originals who had been with the department since its inception in 1968. This has created a great big hole. The staffing procedures within the Federal Public Service are arduous. They often take much longer than you think they will when you start out. My branch did start to search for replacements back last fall, and we are only now in the position of having made 1 appointment, expecting 2 more to come on strength within the next few weeks, and the 3rd, the 1st of May. Hopefully, this will alleviate some of the problems with clearance. Certainly the backlog isn't going to disappear right away. I'm not going to pretend that it will. The requirement is there. It's kind of a catch-22 situation, because in order to look at new ways of carrying out this process, I have to take the very people involved, who are the experts, off the clearance. And at the present moment, I'm not prepared to take them away from doing what you all want them to be doing, in order to examine the procedures and put forward and develop options for possible streamlining in the future, for changing the way in which we go about this mandated legal requirement. That being said, I'm new in the Department of Consumer and Corporate Affairs. I do not have the long-time service in that department, but I did spend a number of years in the health protection branch, and so I have more than a passing familiarity. As a matter of fact, I have quite a good familiarity with the legislation that is administered by the Consumer and Corporate Affairs Consumer Products Branch. What is often referred to in Ottawa as the Nielsen Program Review, which took part in 84, 85, 86, did lead to some decisions by government which are now bearing fruit. Deregulation, regulatory reform, was one of them. The rationalization, consolidation of regulatory activities carried out by what are commonly known as the 4 food departments: Agriculture Canada, Fisheries and Oceans, Health and Welfare Canada, and Consumer and Corporate Affairs. This led to a reassigning of roles and responsibilities, particularly in the inspection area. But it has had impacts upon other areas of food regulation, some more direct than others. Most of you are also aware that the pre-clearance of radio and television advertising for foods and drugs and cosmetics was reviewed around that time, and consideration was given to full deregulation, in which case the Competition Act would become the only means of redress for misleading advertising. It was very interesting at that time because it was expected and known that consumers, through their organizations, would not favor this abandonment of a regulatory area. What was most surprising was that industry did not come on side either. When push came to shove, many of them found themselves asking, is the system we have, with all of its problems, better than unfettered, uncleared television and radio advertisements? And because we are so close to the United States, because we do have spillover advertising, it's quite clear what happens in a less regulated environment. So maybe it wasn't surprising that at the point of decision, they suggested that the beast they knew was better than the unknown, and made their views known at the political level that they preferred to keep the current system. Times have changed. Maybe that interest is not there anymore. Maybe it's time to take a second look at this activity. Maybe it isn't necessary. But so long as it exists as a regulatory requirement, my branch is responsible for carrying it out. It's quite true that it's not a level playing field in terms of print advertising. I don't think there's any possible way that you can have a pre-clearance or a level playing field insofar as print advertising is concerned. The airwaves are finite. The number of publications, the number of sources of print information are infinite. Nonetheless, we do pursue misleading advertising in the same manner when we find it. It's just that the ad's already out there. The damage has been done. And, it becomes a question of what benefit derives from forcing corrective action when the message has already been delivered. That being said, I find it intriguing that even when we do get an agreement to take corrective action, we have to keep on policing to ensure that that corrective action is followed through. And I'm thinking of a particular example, and this is going to be a little difficult for me today because I don't feel that I can name names, name companies. I find myself in a much more delicate position than Sheldon is, even Klaus, whose work with companies is in the public realm. We are dealing with commercially sensitive advertising, and we find it quite difficult to sort of point fingers to name names. I checked with some of my staff about this, and I said, it would be really nice if I could give some examples, maybe hold up some ads, show something, and they said, we prefer you didn't. So I'm going to sort of talk in more abstract terms. But one company we were dealing with not too long ago, who had been required, and this is the first time I've come across mice print, is it? Is this what you call the disclaimer? Okay. Had been required to put a disclaimer in its advertising. In one of the major Canadian magazines, we found the ad and we looked for the disclaimer. Now, the little star was there. It took us 5 minutes to find the disclaimer. It's down on the lower left corner, almost into the binding. Small as possible print. It was written vertically. And not only that, it was black print on a chocolate brown background. You will forgive me if sometimes we're slightly skeptical. The reality is, though, that the pre-cleared ad is seldom, if ever, subject to further enforcement or prosecutorial action. And I think Klaus can back me up on that. I think he also suggested that. Therefore, it's free, and it's almost an ironclad guarantee that you're not going to have any problems with that ad for the period in which it's in use. Is there any other realm of advertising where you get that almost guarantee? I think not. Sheldon mentioned that it might be unfair because if the rules change along the line, practice has been not to require that an ad be withdrawn, but that it hits the next one in the queue coming along. Maybe we should look at that. But I think we're sort of working from tradition, which has said that the ad can be carried so long as its clearance number is valid. That also holds in the marketplace. When we look for corrective action with a company, we do not always require that they immediately remove the offending product from the market. We quite often discuss with them making the required changes at the next label printing, or if that is within a reasonable time period, or in their advertising putting some sort of explanatory note on. Our goal is consumer protection. It's not to keep products off the market. We feel that the Canadian consumer is best served by a fair, efficient, and diverse marketplace. Nonetheless, when we carry out our pre-clearance responsibilities, we are bound by a number of acts and regulations, and yes, by the guidelines. Guidelines are interpretive. They should be used within the spirit of the Act and regulations. But I think you have to understand that the people that are using these guidelines and applying them have a long history and experience in this area. And they bring along that accumulated memory. And I'm not saying that in the context of applying it to company A or company B, but what I mean is that they understand the reasons for the regulation. They understand the discussions that went on with industry when the guidelines were developed. And these guidelines do not spring newborn from the fertile brains of my officials or health and welfare officials. They have been well discussed well shopped around among the industry in Canada. Consultation has taken place with external bodies like the Food and Drug Administration in the U.S. or the U.S. Department of Agriculture. We don't work in a vacuum. We look at what's being done elsewhere. We talk to manufacturers. As a matter of fact, right now on my desk, I have a letter to sign off, which is a response to the Grocery Products Manufacturing Council and their component organizations to a series of comments that they have made about the new guide for manufacturers and advertisers, seeking further clarifications, debating some of the interpretations that we have placed upon parts of the Act or some of the interpretations we have given, and we are responding to them. Some of them require consultation or a ruling from Health and Welfare because we work hand in glove on health and safety issues. But it's not done in a vacuum. And so, in my view, the guidelines do have a solid base. It may not be totally immediate to the legal profession or the advertisers coming in to see us with a particular ad, but it is there. Yes, we are human as well. And maybe sometimes it does get down to nitpicking. Because I have not been operating in this environment for a number of years, probably I'm a little more open to rational argument. Now, this is not to suggest that I want to hear from all of you when my staff say no, but in the few months that I've been in the job, I've engaged them in debate. You see, I'm still in the honeymoon period, and I can say, why, and why again. And I strongly believe in working along established principles. And once those principles are established, applying them fairly and uniformly. Sheldon mentioned a situation in which he felt that different companies have been treated differently. I'm extremely conscious of this, and I think perhaps this is because of where I've been more recently, in the Privy Council office, where you're dealing with policy at the full government level, and where in fact you are responsible for ensuring that one minister's proposals put before his colleagues at the cabinet table have been fully discussed among the relevant departments, that all of the options available have been explored, have been addressed, and that concerns of other departments are noted if they still exist. Coming with this background, it makes me want to know why we do things the way we do them. Makes me want to know what other situations are similar that we've dealt with in the past, and are we dealing with this situation in exactly the same manner? One of the problems with the undertaking to clear advertisements within 10 working days is that quite often the script, the storyboard, the label is our first encounter with the product. And in today's marketplace, these are often new products. They often incorporate new technology for which there may not be a regulation, for which the guidelines just don't quite fit. So what happens is that we end up having to make policy in the context of clearing an ad. I don't think that's the right place to be making policy. And I would like to see the process changed so that, in fact, we can get the policy questions settled first and outside the advertising pre-clearance process. I think this will go a long way to addressing the time problem. You should be aware, in dealing with foods today, that we're pushing at the limits of the Food and Drugs Act in terms of what it allows. Science has made it fairly certain, and it's generally well accepted, that the food we eat can be a factor in the prevention of certain disease states or conditions. And yet we have an act that says that that's an absolute prohibition. So we've been working over the past month or so with health and welfare and with a wide range of health organizations, consumers, professionals, and the industry to see if it's not possible, without having to change the act, because that's probably a 3-4 year process, to develop principles, and from these principles perhaps guiding guidelines, which will allow us to recognize the advances of science and permit some health-orientated advertising, some claims that are related to nutrition and diet. This working group is very conscious that if it wants to move, it has to come up with a voluntary framework which will work, which will be adhered to by all manufacturers and advertisers. And that's one of the problems we face, is the voluntary route, much more flexible. You can get it in place more quickly, but it only works if everybody plays the game. And if everybody's unwilling to play the game, then we're forced into the regulatory mode. That's a long process. On average, from start to finish, it's going to take 2 years. By the time the regulation's in place, it's probably out of date. Technology has moved beyond. Those of you who are active in this area may know that right now there's a regulatory proposal out for discussion and comment that will broaden Section 24, which heretofore has been for meal replacements for weight reduction. There's a whole raft of new products out there that are not a total meal replacement but are based upon a caloric value, very popular with consumers, fit today's lifestyles, but they're not intended for weight reduction only, they're intended for weight maintenance, weight control. And we hope that through this process we'll be able to put in place more flexible regulations which will allow this new product category to be advertised. A lot of the comment about the authority that we use is directed towards the misleading advertising section of the Competition Act. And while it is overriding, I would point you back to the very specific and not totally dissimilar but slightly different sections of both the Food and Drugs Act and the Packaging and Labeling Act in regard to what they say about advertising. And so when you ask, why do you ask to see the label of a product that isn't being shown in an ad? I would take you back to Section 7 of the Consumer Packaging and Labeling Act. And it says that no dealer shall apply to any prepackaged product or sell, import into Canada, or advertise or advertise any prepackaged product, advertise, that has applied to it a label containing any false or misleading representation that relates to or may reasonably be regarded as relating to that product. So that's one of the hooks we use when we ask to see the product label. Some have also questioned why we apply the general impression test to an ad, why we don't just look at it in terms of a specific regulation, nutritional labeling, permitted claims, that sort of thing. Well, we draw our authority and have continuously out of Section 5.1 of the Food and Drugs Act, which says that no person shall label, package, treat, process, sell, or advertise any food in a manner that is false, misleading, or deceptive, or is likely to create an erroneous impression regarding its character, value, quantity, composition, merit, or safety. I don't want to take up all the time you have for questions. One other comment about guidelines. I know they drive lawyers mad, but they do provide safe havens for manufacturers and a fair degree of flexibility. They permit a manufacturer to represent the many and varied characteristics of his or her food products. And as I mentioned, they're much less rigid than regulations are. Our health protection legislation, our consumer protection legislation, particularly as it relates to food, has always had both an economic bias as well as a health and safety bias. I've always been bemused by the fact that the Food and Drugs Act traces its history back to an act of Parliament in 1875, which has this marvelous title, An Act to Impose License Duties on Compounders of Spirits and to amend the Act respecting inland revenue and to prevent the adulteration of food, drink, and drugs. I somehow think the Speaker wouldn't let this one through the House today. It sort of sounds like omnibus legislation. But in my paper, I sort of gave you a little bit of the background on that, which I think is worth repeating and rather amusing in terms of advertising, is that the genesis of this act was the temperance movement. And they were calling for prohibition. Well, if you think back to the politicians in charge of Canada, leading the government at that time, prohibition was probably not a popular policy. So, as often happens, a parliamentary committee was asked to review this situation. And they came up with a finding that liquor itself isn't responsible for society's ills, but it's the bad liquor that's responsible, and it was up to the government to prohibit the sale of bad liquor. We've come a long way. It then moved from adulteration concerns into the setting of legal standards for the composition of foods and the placing of restrictions on health claims and nutritional claims. Interestingly enough, with the nutritional labeling regulations, we've in fact eased up a bit on some of the restrictions that were present before. And of course, the courts have eased up for us on food standards, indicating that if there is not a health and safety concern, the federal government shouldn't be in the business of setting food standards. What's interesting is that this field having been assigned to the provinces, there is, of course, a major trade problem now. And I think that it would be fair to say that most of the manufactured food industry would very much like the provinces to find some means of adopting national standards. There are discussions going on. Obviously, the move towards global trade, the free trade agreement with the U.S., are all moving us in that way to look towards standards that have the broadest possible application. I mentioned that we're trying to open up the labeling of foods, the advertising, the claims associated with nutrition and diet, get beyond the Section 3 prohibition in the Food and Drugs Act. The health organizations are very keen to tap into the money that's to be found with with a link to a major food manufacturer. On the other hand, the food manufacturer would like to have the blessing of a respected health organization. But from my perspective, of course, I sit there and I know that someplace down the line, I'm going to have one of the so-called far-out organizations come in and say, hey, what about me? You know, I mean, I've got just as much a right to put my dietary recommendations on as the Canadian Cancer Society has. And my job is to protect the consumer from fraud, misrepresentation, misleading advertising. And I want to see a system in place, voluntary guidelines, if that's what it is, which I can point to and which will be respected by all the players. I hope we can get there. I think it will be very useful for you, the advertisers, for the consumer as well, and for government. Advertising is getting an edge on your competitor. I recognize that. And I don't think that I'd want to make the marketplace dull by removing that. But believe me, your competitors are the ones who scream first and loudest when they feel that the hype is having a negative impact on their product. Another problem area that we're trying to deal with is the associated advertising, and I can think of something that came into my home and a lot of homes in Ottawa within the last couple of weeks, and this is a packet of coupons, all nicely laid out in a little booklet. And the front few pages of the booklet had health advice, diet recommendations, and information. Second half of the book, products. Just happened to have a quality or a characteristic that meant one of those health prescriptions. Well, you know, we're taking a look at this and we're saying, is it okay? Or is it advertising that is prohibited at this time? We don't have an answer yet on it. Obviously, these new principles will give us some guidance. These are hard questions. And we've seen the impact of the open season in the U.S. We've also seen how it's led to calls from legislators and from consumers and health organizations to rein it in. Right at the moment, the U.S. FDA has recast its proposals and put them out for discussion again. in which it's trying to set a framework for permissible claims for 6 particular types of nutrition or health-related food claims. A lot of people say to us, we really don't want you to move towards the open U.S. system. So please, when you're re-examining this, maintain some controls for the poor consumer who's bombarded by health information and who probably isn't in a position to sort it all out and decide, number one, which healthy lifestyle suits them, which healthy lifestyle they want to follow, and which disease they want to prevent. Because when it all comes, we're all going to die someday, and we're all going to die from something. But the jungle of the U.S., where you ended up, finally, I think a lot of people think the straw that broke the camel's back was the new food product that contained so much fiber that if you'd consumed one bowl of it in the morning, you would have had more of the same kind of fiber than was in the medicinal dose of a very well-known over-the-counter laxative product. Now, when they withdrew the product from the market, they said that this had been a test market and the sales didn't bear it out, but in reality, the FDA had come to them and said, would you please file a new drug submission? I mentioned that I didn't like being forced to make policy in the context of approving an ad. And if I was to leave you with one message, I would say that when you're dealing with a client who is putting a new product onto the market, it certainly would be easier if they'd be prepared to sit down with us and discuss it before they get to the point of having the actors in the studio or the time booked for the ad to address these questions, clear away any of the nitpicking. Sometimes, from our perspective, it's not so much nitpicking as it is bringing it into line with what's been done with other products. We respect the ingenuity of advertisers, the time sensitivity of media campaigns, but we want to ensure that we are giving you the best possible service in terms of consistency and clarity, and it does take time. We may have to consult with health and welfare. We may have to consult with other experts. We may have to go down and talk to Klaus and his people. And it can't be done today or tomorrow. And so if I wanted to leave you with any sort of message, it would be particularly with new products, products that don't fit well within the established regulations and guidelines. Tell your clients to come down and see us ahead of time. One other area that Sheldon mentioned was trademarks. Well, if you've got a client that's spent millions, has probably had 10 years in which the trademark or brand name has been associated with a certain set of characteristics or qualities or a certain type of food product, do you really think that the consumer doesn't associate that brand name with a certain class of product, with certain characteristics? Sure, it's really valuable, but it has a certain meaning. And I think that we're quite right to question if your client wants to transfer the value of that name to a totally new class of product, to a totally new characteristic for which the trademark name has no meaning at all. And this has happened 3 or 4 times since my arrival. And none of these have gone into litigation. In all cases, we've discussed with the manufacturer ways in which he can resolve his problem. In some case, it's required a slight change in the name. In some case, it's required an explanatory disclaimer. And in some cases, it's still under discussion. But we think the consumer has a right to have the characteristics that the product claims to deliver. And if that is part of the brand name, then unless there's some other explanatory indication that the brand name no longer means what it's meant for 10 years, we're going to have problems. I think I've more than used up the time that I should, so I'll just leave it there.
Katharine, thank you very much for your thoughtful remarks. At the outset, you expressed some concern that this might be a hornet's nest. I trust it hasn't proved to be, and I thank you for coming and sharing material. I also don't want to be presumptuous, but encourage you, once the full moon phase is passed, to continue to ask why and why and why. As a practitioner in private practice, that I consider to be a very felicitous attitude. Are there any questions to either of our most recent speakers, please? Yes, sir.
Katharine, you noted a little event that policy. Are you Sheldon, so we go to the black approval and we decide to use policy and we don't have to agree with it. So you can have to go and break it the issue
Excuse me, the Law Society is recording this session, and therefore what I'd like to do, Katharine, is ask you to come up here to respond to the question. And I'll repeat it as I understand it. If in the submission of, for example, a food advertisement, it is refused based upon a policy with which you or your client may disagree, what appeal procedures are available, short of taking the kind of action that Mr. Esbin talked about, namely litigation? As I said, could I ask you to respond up here because the camera is back there? Thank you.
Well, you're quite right. There is no formal appeal process in place. There are, of course, the levels moving on up within the department. I think the dilemma you find yourself in is that there is a time constraint at play here. And I guess what often happens is that when time runs out, another ad is substituted and the discussion either carries on or you go home to change the ad or approach it, try a different approach. I guess I'm not sure whether in fact a formal appeal procedure would assist you in the context of time constraints, because what so often happens is that appeal procedures become bureaucratized, institutionalized in and of themselves. And I think by and large, discussion, meetings is the best way to try and clear it up. I would only hope that that if it does work its way up the system, you do not find closed minds. I know that when you're appealing to the people that have made the ruling, yes, they have, but my experience is that they do not have a totally closed mind, and if you can bring to bear good argument, they're willing to look at it again. But I think once again, it's the time constraint. Well, these are the sorts of hiccups that, over time, some of them are due to resource constraints. I mean, there's no question that throughout, there probably aren't enough lawyers in justice to be totally available to meet all our requirements. I mean, we share the justice staff that's assigned to the department. You know, they're just not available all the time for meetings, and not all the time. And you know, it's quite possible in meetings with health and welfare, or in discussing an issue with health and welfare, they will bring new concerns forward. Part of this rationalization of the roles and responsibilities of the 4 food departments is designed to try and stop this ping pong ball bouncing back and forth. It bothers me. I don't like it. I would like to think that over my time, maybe in some small way, because the will is there, that we can overcome some of this differing viewpoints from differing departments. Well, we've just brought, Pat's one of the new people we're hiring, as you may. No, I know. And, yeah. Yeah. Well, they're not doing them in the broadcasting media. They're just, yeah.
Are there any other questions before Catherine leaves? Yes, sir.
course, from the bureaucrat is to find all the ways in which they can reduce the air to the blandest, least offensive piece of battle possible, with no possible harm to their career, and very little value subsequently to the act. You have a response?
I think it's. I think we would all agree that we don't intend to put Katharine Gourlie in her particular position on the spot in responding to that. You're voicing a frustration. I think you're voicing some truths. My own observation. If we bring this up when we're not required for approval, might the bureaucrat think there's a problem here? It's sort of the syndrome. If I bring a lawyer along, they'll think I'm guilty. This kind of thing, with which I heartily disagree, of course. I think it's fair for Katharine to respond as she chooses, but certainly, I wouldn't expect that she would feel that her own branch is being attacked in that respect. Do you have any response?
Well,
excuse me, a prompt response,
yes.
because food is awaiting us.
First thing, there are no rewards for the most restrictive application of the law or the regulations or the guidelines, as far as I'm aware. Klaus?
I'd like to call upon Mr. Decker to respond to the question, part of which I guess was rhetorical.
This one. Is it on? Well, contrary to what the speaker who raised the question said, under the Competition Act there is no pre-approval or pre-clearance process. What I spoke about was the program of advisory opinions that the Bureau of Competition Policy for a long time has been prepared to give to people seeking advice on future promotions across and other business conduct, contemplated business conduct across the whole spectrum of the Competition Act. I don't think it's our intention to restrict the creative ingenuity of anybody in this. We strictly look at an ad from the viewpoint of the, or a promotion from the viewpoint of the application of the particular section of the Act, and say to advertisers, we don't see a problem, or yes, we do see a problem, and here's the problem. Now, under a program such as, excuse me, such as this, and I might add under the Competition Act, this is not binding on either party because it's a voluntary constructive dialogue rather than the application of a regulation. However, under the program, of course, we would be, I think, ill-advised to take an advertiser to the very edge of legality, under which the advertiser would take, this much of a step and fall over and be in the area where he'd be committing an offense. So what we do under the program, of course, keep people away from that edge, and very much on safe grounds before we would be in a position to provide what we call a positive opinion, saying we don't see any problems. That does not mean that the representation, that the advertisement would be a prosecutable one. So there is a gray area at which we tell people, if you want to go ahead, you're at your own risk. But don't come back to us and saying you've given us comfort. And there has, Mr. McCracken is well aware of a recent situation that we had just such a discussion, where on initial review we saw a problem. We did not, in fact, in that situation, see a problem arising that would indeed, in practical terms, lead us to an inquiry. We couldn't see that. But to be consistent with the standard that we had established in looking at these, and the fairness and equity to other advertisers to whom we give such advice, we were not in a position to say, you have met all the requirements that we feel are necessary for us to say to you, you've got no problem. And so that's how we're approaching this. There's always a gray line, and people are, in the final analysis, under the Competition Act, certainly always free to have the particular representation, particular ad tested before the courts.
Can I just add something, just briefly, very briefly? If what you're referring to is the submission of a label as part of an advertising review, and they won't do it voluntarily in terms of print, the reality is that when we do look at a label, we look at it to ensure that it's in compliance with the Act and regulations. And we'll tell you if it isn't. If we don't look at it, then unless one of your competitors, which is most likely, will bring it to our attention, it may be that we don't pick it up in the marketplace. But I can tell you that in the major food areas, it's more than likely that it will be brought to our attention after you've paid to have the whole product, the whole production run, labeled and all the rest of it. They'll bring it to our attention, and we may come to see you afterwards and seek correction, which is a little more expensive.
Thank you very much. As I said, lunch is awaiting us, and